Intellectual property is often a phrase that's tossed around so much that I think people get confused and they fail to necessarily understand that IP, intellectual property generally, really covers three separate areas. There's trademarks, there's copyrights, and there's patents. Within patents, you have utility patents, design patents, et cetera. So intellectual property protection is a means of ensuring that your IP, your creative work, if you're involved in copyright, your brand name, if you're involved with trademarks, your fashion design, if you're involved in trade dress, or your invention, if you're involved in patents, is protected from third-party infringement. So for example, when a new brand enters the marketplace, one of the first things they should do is go to the United States Patent and Trademark Office and make sure that that brand name is not being used by another company in a similar type of business. If it is, then it's possible that their mark could be considered infringing. Similarly with copyrights, if somebody writes a movie script, if somebody directs a play and they have an actual script, if somebody writes a book, those items are protected via copyright, and you can also register those copyrights with the Copyright Office. Same thing with patents, inventions, designs, and ideas. A patent attorney can go ahead and register patents on behalf of a client to ensure that that invention is protected and third parties can't simply utilize or take advantage of that product without suffering penalties. Whether it comes to trademark infringement, which is very common for better or worse, simply because a lot of small businesses don't even realize that their mark might actually be causing confusion in the marketplace, or copyright infringement because somebody is unaware that there was something else outstanding or out in the marketplace that was strikingly similar to what they're producing. Those are the types of things that we tend to see. But IP also gets a little more challenging when you're in the workplace. For example, you'll have contractors that are hired to perform work for an individual or an employer. And oftentimes the question becomes is, well, what if I create something of value while working for you? Who owns that IP? So that's why in agreements, you always want to ensure that there's a work for hire provision that basically states that the employer will own any of the IP produced by the employee or the independent contractor during the term of when they're working for that employer. We also see other issues concerning licensing and when intellectual property, for example, is authorized to be used by a third party. So in those instances, agreements are usually prepared to basically state that I'm giving you a license, whether it's for a fixed period of time or in perpetuity, to sell my photographs, to use my products, to advertise using my brand name. And sometimes there's compensation associated with that. Royalties can also be had from sales. So these type of arrangements we see happen often, but oftentimes there's also disputes for one reason or another. So when it comes to IP, we also see it with trade secrets of companies and when you have disclosures. That's why a lot of parties will sign an NDA when one party and another party are sort of romantically dancing together, trying to decide, hey, do we want to work together? If we do, and we're going to, let's say, manufacture your product, we need to see your IP. When that IP is disclosed to that manufacturer, you typically want a non-disclosure agreement in place and a confidentiality provision present to ensure that that IP isn't taken or utilized in a manner that it shouldn't be. So all these types of things come into play. IP is a fascinating field of law. It's also got a very, very broad reach. But even when we're negotiating agreements or litigating commercial matters between business partners, intellectual property is always a very intimate portion of whatever it is that's being disputed.